Article 43 of the Hague Convention basically says that the occupier must administer the laws of the occupied state. That's because of the continuity issue.
So going back to your testimony, Dr. Sy, concerning this example of Iraq, and that it became a sovereign state in 1932, it was subsequently overthrown by the United States military forces in 2003. You make the connection to the Hawaiian Kingdom.
Okay. Now, when we talk about the state, we need to understand what was that state and how it existed prior to the overthrow of its government on January 17, 1893. The Hawaiian Kingdom was multi-ethnic, and you also had an alien population that lived here, and everybody was subject to the laws, whether you're a Hawaiian subject or not. Actually, that came out of Section 6 of the Hawaiian Civil Code, specifically, that the laws are obligatory upon all persons, whether subjects of this kingdom or citizens or subjects of any foreign state, while within the limits of these territories. So, the idea of law and country affects everyone within its borders. It does not exclusively apply to Hawaiian subjects. What Hawaiian subjects do have, in distinction to aliens, is that Hawaiian subjects have what is called political rights. Political rights is the ability to participate in government. Aliens do not have political rights unless they become Hawaiian subjects, whether through naturalization, jus sanguinis, naturalization, or jus soli, which is acquisition of nationality by being born on the soil.
Let me get you back to the question. The question is, you set up an example of Iraq where there was a military occupation by the United States. How does that connect to the Hawaiian Kingdom and the circumstances arising in that situation?
Well, at first glance, the overthrow of the government back in 1893 did not equate to an overthrow of the Hawaiian Kingdom as a sovereign state. So that's the part that we need to understand. What my research did, and my larger articles have addressed, is what exactly happened there at that particular time in relation to the government. Because the state continues to exist, but what exactly happened to that government? And that's where I like to share my expertise in and what I've been specialized as far as my expertise.
All right, so...
May I interject?
Go ahead.
And the only question or the comment I'm going to make, Mr. Sy, is sometimes you refer to the state, and I want to make sure it's clear whether we're referring to the state as the Kingdom of Hawaii as it existed then, or whether you're referring to the state as the state of Hawaii now. I just want to make that distinguishment, because sometimes
Good point.
I kind of figure out what you're doing, but I want to make sure it's clear.
Okay, so what we're talking about when you describe a state, tell me what you mean by that.
A state is an independent state. So whenever I use state in my testimony, I'll be referring to the Hawaiian Kingdom. And if I'm going to be referring to the state of Hawaii, then I'll specifically make the point, state of Hawaii.
So essentially, whenever you're stating the term state, you're talking about an independent recognition of a country that's been recognized in the international community as a state.
Right. Now, a lot of people get confused on that. I mean, that's a good point to bring up because, as Judge Freitas brought out, there is a confusion between an independent state and, let's say, the state of California. A state is another word for a country, a nation state. That's where the term comes from. It's an international term. Now, the origin of states within the United States is that when the colonies won the revolution against Great Britain in 1782, which ended the revolution, King George III recognized those 13 former colonies as 13 independent states in a confederation. Thus, these 13 states were regulated by Articles of Confederation. It wasn't until 1789 that these 13 states gave up their independence as independent states and merged into a federated state, which is since then called the United States of America. Now, Pennsylvania, that used to be an independent state in a confederation, now became a state within the federal union. And that's the origin of the states within the United States. What I want to do is get into the point of what happened with that overthrow, because there were negotiations that took place regarding the government itself, but not the state.
What were those negotiations?
They're called executive agreements.
And in the executive agreement, who were the parties involved?
President Grover Cleveland and Queen Liliuokalani.
And what was the substance of those agreements?
The first agreement was an assignment of executive power. The Queen was vested with the executive power pursuant to Article 31 of the Hawaiian Constitution. Her job was to faithfully execute the laws of the Hawaiian Kingdom, no different than the President to faithfully execute the laws of the United States. One of those laws that she was required to ensure that was enforced was the treason law, Chapter 6 of the Hawaiian Penal Code. Certain individuals on January 17th were going to commit treason, declaring themselves to be a provisional government. The U.S. Marines were landed by order of the U.S. ambassador over the protests of the Hawaiian government officials the day before. These officials did not know the reason for the landing of the U.S. troops, who were fully armed. They found out the next day that these U.S. troops were used to protect the insurgents. So the Hawaiian police force, at that time headed by Marshal Wilson, was unable to arrest the insurgents or apprehend them for the violation of the treason law without running into the U.S. Marines. The Queen was then faced with a situation: risk bloodshed or have the U.S. President investigate the actions of their diplomat and military. So on January 17, 1893, the Queen yielded under protest, temporarily yielded and assigned her executive power to the President for him to do an investigation of his diplomat and military, remove the military, restore the government, and return that executive power.
Hold on. So she yielded her authority temporarily and conditionally
Right.
to the United States until such time that an investigation would undo the wrong.
Right. And she yielded it not to the United States of America, she yielded it to the United States President, the chief executive, who was responsible for the U.S. troops that have landed and the diplomat that ordered the landing.
And in her address to the United States President, her desire at that point in time was to shift the responsibility to the United States President?
Because she could not faithfully execute the law.
I see. Now, you mentioned earlier in your testimony that there was a Liliuokalani assignment. Can you further elaborate on that assignment?
That assignment was an assignment of executive power. People didn't really understand what that assignment really meant, and that's why it became the basis of my doctoral dissertation and several law journal articles. In looking at the idea of separation of powers doctrine, how it was played out and fully enshrined in Hawaiian constitutional law, and the limitation upon which the Queen had when she yielded that authority. She did not yield the country. She didn't have it. She was a constitutional monarch, limited to execute the laws of the country.
And at this time, when she yielded temporarily her authority, executive powers, to the President, that was in 1893, correct?
January 17, 1893.
Who now holds that executive power?
Well, according to executive agreements and U.S. constitutional law, executive agreements bind successor presidents to their faithful execution.
And today, who now holds that executive power?
Would be the office of the President, currently occupied by Barack Obama.
Okay, once again, let's get back to the question, which is, what is an executive agreement?
An executive agreement is not necessarily a treaty, but yet it would fall under the status of a treaty. And the cases that elaborated on that was United States versus Belmont, United States versus Pink, and American Insurance Association versus Garamendi in 2003. So what basically you have is, under the U.S. Constitution, Article 2, the President is the chief executive. He represents the United States in foreign relations solely. Pursuant to the separation of powers doctrine, Congress nor the courts can extend beyond the borders of the United States. The President is the only party that can. And he's represented in foreign relations through diplomats and military. So the President himself does not travel around the world. He is represented by diplomats and military. Now, there are three types of treaties that the U.S. Constitution recognizes. If an agreement between the United States and a foreign state involves a rule of U.S. law, whether a duty, import, migration, trade, it needs ratification from the U.S. Senate pursuant to Article 2 of the U.S. Constitution. 2/3 of the Senate must ratify it. If the agreement does not involve a matter of U.S. law, the President can enter into an executive agreement whereby, under his sole authority with that foreign nation regarding his military or diplomat, which he does not need to take before the U.S. Senate for approval, that he operates by virtue of his sole authority. That's called a sole executive agreement. Now, the President can also enter into another executive agreement whereby Congress will consent, and that's what is called a congressional executive agreement.